Mr. Jahan, lecturer, Department of Law, World University of Bangladesh. According to Section 34 of the ICT Act 2006, every certifying authority whose license is revoked or suspended, as the case may be, shall immediately after such revocation or suspension surrender the license to the controller. So, under Section 34, it is mandatory for the certificate authority to surrender his revoked or suspended license. If he fails to surrender his revoked or suspended license under Section 34, then such failure will be contravention of this ICT Act 2006. Whoever commit offence under subsection 1 of this section 58, he shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to Taka 10,000 or both. Section 59. According to Section 45, the controller has power to give direction to the certificate authority or any employee of such a certificate authority. The controller may, by order, direct a certifying authority or any employee of such that certifying authority to take such measure or is carrying on such activity as is specified in order if those are necessary to ensure compliance with the provision of this section 59 or rules or regulation. To comply with such order is an obligation for the certificate authority or employee of such certificate authority. If any person fails to comply with any order under section 45 of this act, then such failure will be the contravention of this act and be treated as an offense. Whoever commit this offense, he shall be punishable with imprisonment for a term which may exceed 1 year or with a fine which may extend to Taka 1 lakh or both. Under section 46 of the ICT Act 2006, the controller under the following emergency situation can give direction to any agency of the government to intercept any information to be transmitted to any computer if he thinks it necessary and expedient. Number 1, in the interest of the sovereignty, integrity and security of Bangladesh. Number 2, friendly relation of Bangladesh with other states. Number 3, keep public order. Number 4, for preventing incitement of commission of any cognizable offense. So, under section 46, the direction is only applicable for government agencies in which the controller has directed to take a step in emergency situations. If the government agency fails to comply with order made by the controller in emergency, then such failure shall be treated as contravention of this act and regarded an offense. So whoever commit offense under subsection 1 of this section, he shall be punishable with imprisonment for a term which may extend to 5 years or with fine which may extend to Taka 5 lakhs or both. Now, section 61. Section 61, there are a number of important security concerns relating to computer and internet. Many of these are computer crime because computer and network are so widespread and give many opportunities to criminal for committing criminal activities. All computer users, including government agencies, must be aware of the risk of using network and computer. Two risks related to this network and internet are unauthorized access, unauthorized use. To prevent these unauthorized access, unauthorized use, there must be protected system to be applied to the computer system and the computer network. So, what is this protected system? A system relating to computer system, computer network will be protected system when the controller by notification in official gazette or electronic gazette declare any computer system, computer network as protected. And again, according to section 47, the controller has the power to announce protected system in respect of any computer, computer system, or computer network. A person who is authorized by controller under section 47 can only access to such protected system if any person contravening section 47 access or secure access or does unauthorized access to any protected system, then such access shall be an offense. So, what are the conditions? There shall be an unauthorized access or attempted to access to any protected system. Number 2, the system must be declared as protected system according to section 47. And number 7, the access must be contravention of section 47 of this act. So, whoever commit this offense under subsection 1 of section 61 shall be punishable with imprisonment for a term which may extend to 10 years or with fine which may extend to 10 lakhs taka. Like for example, the computer network of Bangladesh Army is declared as protected system under section 47. So Sharon runs a password cracking software to crack password of this protected system. Irrespective of whatever he succeeded in cracking the password, he is guilty of attempting to secure this access. Misrepresentation and obscuring information from the controller or certificate authority for obtaining any license or digital signature is a cyber contravention. Section 22 and 23 states that certificate authority must fulfill required qualification, expertise, manpower, financial resources, and certificate practice statement, evidence of payment of defined fees, and such other document as prescribed. But if the applicant, either certificate authority for license or subscriber for digital signature certificate, make misrepresentation to or suppose any material fact mentioned above from the controller or the certificate authority, then such misrepresentation or obscuring information will be an offense under section 62. Any person who commits such offense shall be punishable within the imprisonment for a term 2 years or with fine which may extend to taka 2 lakhs or can be both. Section 63. Privacy is the right of people not to reveal information about themselves. This section is a safeguard against disclosure of confidentiality and privacy. Article 43 of the Constitution of Bangladesh guaranteed right to privacy as to home, correspondence, and communication. And it provides that every citizen shall have the right to secure in his home against entry, search, seize, or to the privacy of his correspondence and other means of communication. The main purpose of Section 63 are to ensure the corporate responsibility, ensure confidentiality, integrity, to protect disclosure of confidential information, protect privacy, to the act of government employees and person, any person who is in charge of government offices and not authorized to access any protected system relating to computer, computer network, or computer system, but accesses and discloses electronic record, book, register, correspondence information which is confidential for the government, then such shall be treated as offense under section 63. Under this section, section 63, disclosure of confidentiality and privacy is an offense. Here, disclosure of confidentiality and privacy means the disclosure of electronic record, book, register, correspondence, information, document which are treated as confidential. Rules relating to confidential information has been maintained in Rule 34 of Information Technology Rules 2010. So, publishing a false digital signature certificate is an offense under section 64. There are 3 ground mentions under this section when publishing a false digital signature certificate will be treated as an offense. The publishing of digital signature certificate by the subscriber will be an offense if the certifying authority listed in the certificate has not issued it, or the subscriber listed in the certificate has not accepted it, or the certificate has been revoked or suspended. Whoever commit any offence under subsection 1 of section 63 shall be punishable with imprisonment for a term which may not exceed 2 years, or with fine which may exceed 2 lakhs, or both. Section 65. The difference between section 64 and 65 is that under section 64, the digital signature certificate must be false, but under section 65, digital signature certificate may not be false. To accuse a person under section 65, the intention behind the publishing of such digital signature certificate shall be taken into consideration. If the purpose of publishing of digital signature certificate is for fraudulent, then such publishing shall be treated as an offense under section 65. Generally, the liability for publishing false digital signature certificate is on the subscriber on digital signature certificate issued in his favor. But if any person in the name of subscriber publishing digital signature certificate will also be held liable. So whoever commit any offense under subsection 1 of section 65 shall be punishable with imprisonment for a term which may exceed 2 years, or with fine which may exceed 2 lakhs, or both. Cyber criminals use computer network for criminal activities. Computer can be used for committing a crime in one of the following ways: as a tool, as a target, both as a tool or target. The first type of crime is basically an extension of real-world crime, such as forgery, fraud, copyright piracy, using computer. At present time, computer is used as a tool of committing crime. Existing law can be used to bring criminals to justice. The second type of crime is a real cybercrime in which culprit damage or modified the victim computer system network through illegal access, or cause heavy loss to the victim, such as hacking. If any person uses computer as a tool for committing offences referred in this act, or if any person assists committing crimes referred under this act using any computer, email, computer network, resources, or system, then such use or assistance to use of computer to commit crime will be an offense. For example, Abdul, using computer, makes a duplicate copy of Babu's SSC certificate. Then A used his name instead of Babu's name and tried to pass of the duplicate copy of the certificate in the name of Abdul. And here Abdul commits a forgery using computer. This section does not provide any punishment. Rather, it has been said that whoever aids committing any offense under subsection 1 of this section shall be punishable with the punishment provided for the core offense. As Abdul commits forgery, so Abdul will be liable for forgery under the penal code. Section 67. This section outlines the person who will be liable for commission of offences and contravention referred under section 67. This section states that if any person is committed by a company under this act, then each director, manager, secretariat, partner, officer, staff of the company who has directly involvement in committing the said offense shall be guilty of the offense or the contravention. The employee can involve themselves committing any offense referred in this act. So most common fraud, charter fraud, involved credit card, telecommunication, employees' personal use of computers, unauthorized access to confidential files, unlawful copying of copyright, licensed software. Worker may use information technology for personal profit or steal hardware or information to sell. This section also provides the defense from being exempted from such liability. The director, manager, secretary, partner, officer, and the staff of the company who has directly involved in committing the said offense shall not be guilty of the offense or the contravention if he proves that the offense or contravention was committed without his knowledge, or that he exercised due diligence in order to prevent commission of such offense or contravention.